All right, good morning, everybody. We're here for various motions. State, please announce your presence.
Good morning, Your Honor. Michael Rosinko for the state.
I can barely hear you.
Can you hear me now, Your Honor?
It's a little bit better, yes.
Michael Rosinko.
My volume or your microphone? All right. All right, good morning, Maria. Hello.
Good morning, Your Honor.
Good morning. All right. All right, is Mr. Calderon. Good morning.
Morning, Judge.
How are you, sir?
Good. Yourself?
Well, let's see. I've got two petitions to expunge.
Yes, sir.
We'll start with 20 MM 1653.
It should be Sabrina Silva, Judge.
Yes, sir.
It's just her affidavit, the certificate of eligibility showing she is eligible to have this case expunged should be in the court file along with the petition. We'd ask that this case be expunged.
All right. I'm reviewing the file now. There is a petition to expunge. There's a supporting affidavit. There is a certificate of eligibility. I am showing payment to the clerk in the amount of $42. State, any objection?
No objection from the state, Your Honor.
All right. That motion is granted. Mr. Calderon, you'll get me in order?
Yes, Judge. This morning. I'll get it to you today.
Very good.
The second one I have, Judge, is Merlange Sylvain. It's 2020 MM case 1591.
All right.
To expunge. All the necessary paperwork should be in the court file along with a $42 payment.
All right. Once again, I'm reviewing the court file now. There is a petition to expunge, a supporting affidavit. There is a certificate of eligibility indicating an eligibility to expunge, and a payment of $42 to the clerk is reflected in the record. State, any objection?
No objection, Your Honor.
The motion is granted.
Thank you, Judge. I'll get that order off as well.
Happy holidays to you.
Yeah. Merry Christmas.
Take care.
Thank you.
Mr. Vitale. Good morning.
Good morning, Your Honor.
How are you, sir?
All right, how are you?
Doing well. I've got William Thomas Watkins, 19 MM 543.
Yes, sir.
Okay.
This is Mr. Watkins' motion for return of his property, a shotgun, I guess, as pursuant to the battery charge that he was charged with. The court issued a no firearms order and took the shotgun into evidence. I'm not sure why it was not used in the commission of the crime.
Was it evidence, or was it turned over pursuant to the no firearms order?
It's in evidence right now, so I don't know if how it got in there, but it is in evidence. The case is over. It's long been over. It was just a simple battery charge. I think the weapon was a bottle of shampoo. So in any event, there will not
Can you
release.
fire that from a shotgun?
No, I don't think so.
All right.
But in any event, the sheriff's office will not release it without a court order. So we filed the motion.
All right. State, any objection?
No objection, Your Honor.
All right. The motion is granted.
Thank you, Your Honor.
Thank you, sir. Just give me an order, please. Take
Yes,
care.
sir.
Happy holidays to you.
Happy holidays, Judge.
All right. Mr. Bertoramo. Good morning.
Good morning, Your Honor. I have two on the docket.
Yes, sir. Let's see. I've got Gustavo Manuel Ruiz Hernandez, 19 CT 2341, motion for early term of probation. I do have probation present.
Judge, our motion indicates that Mr. Ruiz Hernandez was arrested on October 7, 2019. Resolved his case on February 24th of 2020. He's placed on 12 months of probation. There was a violation during the duration. There was a dismissal of the violation on August 17th of 2020 and June 4th. There's a lot of activity on this case. There were some SoberLink violations, which were ultimately dismissed with confirmations of ETG tests. Mr. Ruiz Hernandez is compliant with all conditions of his probation and has satisfied all monetary obligations, and I don't believe anything remains outstanding at this point.
Would probation like to be heard?
Good morning,
County Probation for the record.
Good morning.
Our objection basically is
I can't hear, Judge.
Can you come up to the lectern, please? I'm sorry.
our objection on this case is the fact that he has violated the first violation and the second, which was dismissed. He's on probation for 12 months. He's got 2 more months left to go.
All right. State, would you like to be heard?
Yes, Your Honor. The state objects to the early termination. The defendant had the violation on 4/21 that he admitted to, and the state thinks it should be reserved. Early termination should be reserved for someone who successfully completes the probation.
What are the date of the violation? 4/21?
4/21. And there was a modification of probation extending the sober link, I believe, for another 90 days.
Correct. I see the date.
Wait just a moment. Well, there were 2 violations, right? There's 2 violations, one that was admitted to and one that was dismissed, but there
One
were
that was
2
dismissed.
alleged violations.
Yes.
Correct. The initial violation from 4/21 was the violation that the state is talking about.
Right.
And unfortunately, as the court's aware, there are some issues with providing confirmation to an ETG test. We were not notified properly in time. The second violation, there was an allegation that there was alcohol consumption. My client immediately went out and had an ETG test, which confirmed there was no alcohol in his system. So those were the issues. There were sober link issues.
Right.
It's been 8 months since the initial violation. The initial violation was a .007 BAC, .007 BAC on the sober link. So with the state and I had, as Mr. Stewart and I worked this case out to where since it was such a low breath reading, and there was issues with the timing of when Mr. Ruiz Hernandez was notified of the positive reading on the sober link, we continued sober link to allow him to prove to the courts and to probation that he's not consuming alcohol. Put him back on sober link and it happened again, but unfortunately we were notified in a timely manner to where he could disprove that he had consumed alcohol.
Right.
Your Honor, yeah, this was for his second DUI, and there was, he did admit to the first violation.
All right.
Judge, I don't know if you have the affidavit for the first violation that the state's referring to.
I do.
Okay, because the allegation under condition 8 specifically states that there was a .007 reading.
Yeah, but there was one moment. That was condition 8, but there were other conditions that there's also a .020. There's a .00. There's a .007, but there's also a .020 that was admitted to.
In the same affidavit?
And just generally, reviewing the probable cause affidavit,
You must be looking at a different affidavit than I have, because I only see the .007.
I'm looking for amended affidavit violation of probation that was filed on April 20th, 2020.
Okay.
And there were 2 condition 8 violations. One was alleging that on April 6th at 10:52, the defendant tested positive 0.007. The next condition 8 says that on April 16th at 10:25 a.m. tested positive 0.020. And so, you know, and that VOP was admitted to.
Correct.
And then if you look at the, you know, and then looking at the booking sheet itself, this was a second DUI. The prior was in 2012. And this one, he was impaired enough that he was driving down the road with no tires on the driver's side. So when looking at the prior criminal history, the fact of this particular case, and the fact that there was the one prior violation, the motion for early term is denied.
Thank you, Judge. I've sent a proposed order to your judicial assistant.
Yes, sir.
Have it.
All right. And then we've got one more. Gregory Philip Clifford, 20 CT 401.
Mr. Clifford, I believe, is joining us. Let's see. Yes, he is.
Mr. Clifford? Good morning. You can go ahead and unmute if you'd like to.
Can you hear me, Judge?
Yes, sir. Yes, sir, I can. Good morning.
Good morning.
Judge, I filed a motion to convert the community service code monetary obligation. Mr. Clifford was sentenced on July 20th of 2020 to reduce charge of reckless driving with property damage and placed on 12 months of probation. One of the conditions of the probation was to complete the 50 hours of community service. Mr. Clifford is considered a high-risk individual due to his health issues. He has epilepsy.
Okay.
In working this case out, I sent the medical records to Mr. Stewart, which was also part of our defense, ironically, as well. But due to COVID, Mr. Clifford has been advised that his immune system could be compromised as a result of his seizures. I've reviewed the medical records again this morning, and I can do my best to show them to the court. That the state should have them if they're uploaded into the court file.
Well, let me start with it. State, are you objecting to the motion?
No, Your Honor, no objection.
Mr. Verderamo, I'll take your representations
Okay.
under the circumstances. The motion is granted.
Thank you, Judge. And do you have that order as well?
I don't have it in front of me. I'm sure. Oh, yes, I do.
Okay, great.
Yep. Yep. All right. Yes, ma'am. I know. I mean, let me put it this way. It's my intention to be as flexible as possible right now with that, but I am bound by the statute. And so I'm going to thread that needle as carefully as I can. But
I could.
I think this would qualify as a hardship under the statute for employment purposes, given your client's health issues.
Right. And when the statute was enacted, we weren't taking COVID into situations.
No, we weren't. But you know, a pandemic doesn't change the law. So, as I said, I will thread the needle with you know taking reality into account.
And I have no idea what that individual was saying on the other end. I couldn't hear.
As Torres, she was just letting me know that because of the rising numbers, opportunities to perform community service are limited right now.
Oh, okay, gotcha.
Which, you know, makes sense. So like I said, I can't, first day is when I wrote 22nd day. Okay. So like I said, I have to follow the law no matter what's happening, but I can also do what's right under the circumstances. Okay. All right, so the motion is granted.
That's all I have, Judge. Have a nice day. Thank you.
Yeah, he's here.
Okay, can you take this case to interpret just that one case?
Yes, I can. All right, thank you, Mr. Burrow.
Thank you. Bye.
Bye-bye.
What would you like me to bring on?
Perhaps on the, yeah. All right, Mr. Lopez. There's a gentleman who's sitting.
Good morning, Your Honor.
Good morning.
As the gentleman on my other device is my client, I have a motion to convert community service to fines in his case.
Okay.
Case is Cepeda Prieto, 20 CT 483, He's on probation. One of his chances, community service.
I know.
Requesting the court to, for an order to convert that to fines at the rate of $10 per hour.
Mr. Lopez, I've got an interpreter present in the courtroom. Did you want him to assist you for Mr. Prieto, or do you want me just to proceed without having to go through the interpreter? It's your call.
I would ask for the interpreter to assist.
All right. Then you're gonna have to go slow enough that he can then, repeat so your client can hear.
Acá pues va funcionando.
All right.
Su señoría, el cliente mío, Pavel Cepeda Prieto, esta calculatoria 20CP483, y estamos aquí para una petición para convertir las horas de servicio para la comunidad a cuotas. Thank you, Ron.
Thank you. All right. State any objection to the motion?
No objection, Your Honor.
¿Hay alguna objeción a la petición? No, no hay objeción.
All right. And as I was discussing with Mr. Verderon, Mr. Lopez, the basis of your request is?
Sí, como yo estaba hablando con el señor López, la base para su petición es ¿cuál?
On the basis of that is that Mr. Cepeda Prieto works a lot and has limited time to complete community service. He is able, he's more able to pay the fines in cash and pay it off in cash at a rate of $10 per hour for the 50 hours he is supposed to do.
Señoría, la base es que el señor Cepeda Prieto trabaja mucho y por lo tanto tiene su tiempo limitado para completar las horas, pero puede pagar con dinero las horas de servicio para la comunidad en efectivo a razón de $10 por hora para completar las 50 horas.
So just so you know, I mean, you look at 316.1936A are only limited circumstances under which I can allow buyout of community service hours.
Señor López, solamente para que usted entienda, según la ley 316.193.6A, a las instancias en las que se puede permitir este tipo de conversión son bastante limitadas, según la ley.
However, based upon the representations of counsel,
sin embargo, según la representación del abogado de la defensa,
that the defendant works a significant number of hours per week,
el acusado trabaja un número considerable de horas semanalmente,
find that he does qualify for the hardship to allow the buyout of community service
yo
hours.
sí voy a fallar que él sí califica para poder comprar las horas de servicio para la comunidad.
Motion is granted.
I'm sorry.
Motion is granted.
Por lo tanto, la petición es concedida.
Can you get me an order, Mr. Lopez?
¿Usted puede enviarme la orden, señor López?
Yes, I will submit an order.
Very
Sí,
good.
yo voy a presentar una orden.
As long as I have a reason that conforms to the requirements of the statute, I can work with you.
Porque siempre que yo tenga una razón que conforma con la ley, pues yo puedo hacer algo.
Okay? Sure.
Señoría, si puedo decir algo sobre este caso antes de proceder.
I have been trying probation to find the whole data of the court for December and even to report it to
El Departamento de Libertad Probatoria se ha estado tratando de comunicar con el señor Cepeda para el mes de diciembre y necesitamos que se presente electrónicamente lo antes posible.
Can he report today?
¿Él se puede presentar hoy? Sí.
Mr. Cepeda,
Señor Cepeda,
probation has been trying to reach you.
la gente de la Libertad Probatoria ha estado tratando de comunicarse con usted.
You need to go to the courthouse today. Oh, no, I'm sorry. You can do it electronically. You need to report electronically today.
Usted necesita comparecer electrónicamente hoy.
You understand?
¿Entiende?
All right. Mr. Lopez, if he has any questions about that, please help him. Probation
Señor
wants
López, si tiene alguna
wants him to
pregunta
report
al respecto,
immediately.
por favor, ayúdele.
Okay?
¿Está bien?
Yes, Your Honor.
All right.
Sí, señor.
Thank you.
Gracias.
Thank you.
Thank you very much. I appreciate your help.
Thank you, man.
All right. Mr. Hopkins, are you there?
Your Honor, good morning.
Good morning.
Your Honor, I'll defer to Miss Senna Charles. She looks like she may be there too, and from your
Sure.
docket, she's not reflected, but I know she has a petition to seal, so she should be quick.
Okay.
Yes,
She-
Good morning. How are you?
thank you, Attorney Hopkins. Good morning, Your Honor. Attorney Hills of Senator Charles.
Okay.
I am here on, my client is Franklin Centius, and the case number is 86MM231.
I'm sorry, yes, ma'am. I'm sorry. I was going off the docket and your name wasn't as counsel of record. I apologize. I would have.
Oh, it's okay, no problem, Your Honor. The motion, the affidavit, the FDLE certificate, all these documents have been submitted as part of the file, Your Honor. And I did email an order to your JA yesterday.
The petition to seal.
Yes, Your Honor. No, I'm sorry, to expunge.
No, it says petition to seal on top. Let's see.
Okay.
On April 24th, 1986.
That is, yes, Your Honor, that's a very, very old case. But my client is still having issues with this case.
Okay. And it's had no problems since 1986, so it would otherwise be eligible.
Yes, Your Honor.
Okay. Give me 1 second. All right, well, Senator Charles, I don't mean to be a stickler, but the petition does ask for seal.
I will send you the order to seal then, Your Honor. I think I sent you the wrong one.
And the certificate of eligibility is for seal.
Okay.
Are you looking to seal or are you looking to expunge? Because I can reset this and allow you to redo it.
Well,
Both the petition and the certificate are to seal the records, not to expunge. If you're seeking expungement, I can allow you to redo it if you'd like.
at this point, Your Honor, let me go ahead and I'll just go ahead and expunge it at this time.
Okay,
Because I
you
would
want me
need
to
get
to reset it?
Can we seal it? And I could just send you another order at this time, Your Honor.
I can't do that. I can't just seal it and then expunge it later.
Okay.
I would need a certificate of eligibility from the FDLE. What I'd rather do is just reset the matter and allow you to refile your petition and obtain a new certificate if he's otherwise eligible for expungement.
The thing is, I think we tried to do that initially, and they told us we needed to go this route first.
So because you wanted to seal.
Yes.
And then if he's sealed for 10 years, then it can be expunged.
Yes.
Okay. All right. Well, in that case, state any objection.
No objection to the petition to seal, Your Honor.
Okay. I'm not showing. Was there a payment made? Let's see.
If the 42 wasn't paid, Your Honor, I will go ahead and pay that. I thought because this case has been pending for so long, I thought we paid the 42, but if not, I can have my assistant go and pay that.
Maria, can you check for that for me, please?
I don't see anything in the case, Your Honor.
All right. The petition will be granted upon payment of the $42 to the clerk.
Thank you so much, Your Honor.
All right. Thank you, ma'am. Happy holidays to you. Take care.
Thank you. Same to you.
All right. Mr. Hopkins?
Yes, sir. Your Honor, Mike Hopkins, I have two cases with probation in the state, two motions to early terminate probation. If we could take State v. Katrina Erickson, 19 CT 2771 first.
Okay.
Your Honor, in that case, Miss Erickson pled, and she pled on August 20th to a DUI first below a .15. There was a negotiation with the state. You'll see in the JNS, it says the possibility for early term after 4 months. That was specifically through the negotiation because the defendant withdrew a motion to suppress that had been filed. I think what probation will indicate to you is that she's been in compliance. She's just right past the 4-month mark and has, certainly met like her counseling conditions, education conditions. I know that's one of the concerns for the court. She's also primarily, well, not primarily, she's also an Illinois resident. So she's on mail-in electronic reporting. So based on that, no violations and what the agreement is, and then her compliance just with the treatment and then all the conditions, that's the reason for the request, Your Honor.
All right. Would probation like to be heard?
Your Honor, probation has no objection to early termination once she pays the $75.
Okay. Mr. Hopkins, I don't know if you could hear that. Apparently there's a $75 outstanding, but otherwise probation has no objection. State?
Understood.
The state has no objection once the $75 probation fees.
Very good. All right. Mr. Hopkins, the motion is granted. And if you just want to put in the order upon payment of any outstanding financial obligations.
Understood. I will do so.
Yes, sir.
Okay. And Your Honor, I don't know if our office went ahead and submit the proposed order. If you see a proposed order on this, please disregard it because I'm going to be submitting a new proposed order with that language.
Very good.
Okay. The next case is Ryan Lindsay, 20 CT 118. Your Honor, Mr. Lindsay pled to an amended charge of reckless driving on September 24th. The sentence was 6 months probation with the possibility for early termination after 3 months. 3 months would actually be in 2 days. So I'm requesting an order based on probation's confirmation of his compliance. It's my understanding not only has he been in compliance, but he's completed everything, but effective on December 24th would be my request to the court. So I'm not trying to deviate from the plea agreement and what was agreed to.
Trying to get us out 2 days.
Yeah, it's 2 days because otherwise if we get past 2 days and then I bring the motion, then he's going to owe another $75.
I understand. All right. Probation has no objection. State?
No objection for termination on the 24th.
All right. I'll tell you what. All right. You were going to hold you to the 24th. Okay. I was going to give your client an early Christmas gift, but I suppose we'll.
Well, I appreciate the court hearing it, and I appreciate the court saying that. Like I said, I'm not trying to change, what the agreement was. It's just that we're bound by the court's hearing dates and when we can bring the motion. So.
The motion is granted.
Thank you, Your Honor. I'll see you tomorrow.
Thank you. Yes, sir. All right, Mr. Wilson. We've got the state's motion to revoke bond. Thank you for your patience, sir. All right. This is 20.
Good morning, Your Honor.
Good morning, sir. This is 20 MM861 James Prudhomme. Mr. Osenko, this is the state's motion.
Thank you. Your Honor, the state is asking the court to revoke bond in this case on the following grounds. On June 4th, the defendant was charged with battery and a KPS warrant was issued. On the 22nd, he was arrested for driving while license was revoked or suspended, third offense. And then on November 1st, he posted bond. And on November 12th, the defendant was arrested in Lee County for resisting an officer without violence. Your Honor, the state requests that the court revoke bond due to the defendant violating his pretrial release by getting arrested for a new law violation on November 12th. And the defendant is still in custody, Your Honor, in Lee County. It's the new violation is a Lee County case.
Mr. Wilson?
Yes, Your Honor. My understanding, obviously, we're going to object to it because he is in Lee County. My understanding is that new Lee County arrest did result in either him having the bond revoked.
Give me one moment. I'm just reviewing the probable cause affidavit. alleged to have stolen a computer from a hospital,
Yes, Your Honor.
and he was arrested on his birthday. Mr. Wilson, I respectfully, the state's motion is granted.
Yes, Your Honor.
Now, since he's in custody, Mr. Cinco, normally on these orders to revoke bond, they're kind of phrased like a warrant. You know, we have to have the identifying information, everything, so law enforcement can go get somebody. Given that he's currently, and you've confirmed he's currently in custody as of today.
Yes, Your Honor.
I don't know if we need to go through the trouble of having the full detailed warrant ordering the sheriff's office to pick him up. I think if it's up to the state how you want to phrase that order to ensure that he is not released from Lee County's custody until he is brought back to address our matter here.
Okay, thank you, Your Honor. I'll send you the order.
Very good. All right. Is that all? Is all you have today, Mr. Wilson?
Your Honor?
Is that all you have today?
Yes, Your Honor.
Okay. Thank you, sir.
Thank you.
If I don't see you tomorrow, because tomorrow is my private counsel docket. Merry Christmas. Happy holidays. What's that? You're with me for 24s?
Yeah.
I'll see you then.
Yep.
All right. Take care.
Thank you.
All right. I've got 2 more on this morning's docket. 2006 CT 724. This is a state's motion to withdraw capias.
No, Judge, that's a defense motion.
Oh. It's a defense's motion. I'm sorry. Hector Allen Rivera Jr. And he also he filed a motion, sent in a plea in absentia. Is this an agreed upon plea?
Yes, Judge, I've been working with that attorney and his assistant, and we negotiated this plea. I reviewed the plea in absentia. They filed it. They were supposed to send fingerprints. I'm not sure if they're in the file. And then I told them on top of that, after the court accepts the plea, they have to ask the court to withdraw the bench warrant.
Did you know if he was planning on showing up today?
They call them capiases.
I'm sorry, I couldn't hear that last part.
Oh, I said, as you know, in other counties, they call bench warrants capiases.
Right. Oh, right. What would you like me to do? I can reset this so counsel can show up, or I can just address it because it's all agreed to by the state.
That's up to you, Judge. I know they're from the East Coast.
They still show up for court in the East Coast.
I mean, I don't know if there was a miscommunication or maybe they didn't understand they had to come on Zoom. I'm not sure.
All right.
Unless we're early, is it scheduled for 9 or 10?
I believe it's on the 10 o'clock docket.
Oh, it's on 10 o'clock? Oh, then I take everything I just said back.
Okay.
So I take it all back.
So maybe we just wait till 10.
Well, yeah, 10 o'clock. All right, we'll wait till 10. I don't.
You can go to the jail now if you like.
All right, so the other one we have is Bruce Knoll. Apparently Mr. Knoll is in custody.
Yes, Your Honor.
So I'm gonna switch over to courtroom 3-4 so we can address him because he's unrepresented. I need to make sure he's present for the hearing. All right.
Thank you.
So I'm gonna log off Zoom for a moment and I'll be right back with you.
All right, thank you.
Bye-bye.